Minnesota Real Estate State Exam Prep. Question 1. Which Minnesota tax is generally associated with recording a deed that conveys real property for Finley in Minneapolis involving a mixed-use property priced at $384,500? Option A. State deed tax. Option B. Mortgage registry tax only. Option C. Utility franchise fee. Option D. Federal gift tax return fee. The correct answer is option A. State deed tax. Deed tax is generally associated with recording a deed conveying real property. Mortgage registry tax relates to mortgage debt, while utility franchise and federal gift tax issues are outside the ordinary deed recording charge. The transaction document determines which tax applies. Question 2. A social media ad for a single-family home in Woodbury uses a team name. What must the advertisement clearly and conspicuously display? Option A. Only the salesperson's nickname. Option B. The real estate brokerage name. Option C. Only the property street address. Option D. Only the team logo without the brokerage. The correct answer is option B. The real estate brokerage name. Minnesota advertising rules require the brokerage name to be clearly and conspicuously displayed. A team name may be used only with broker authorization and the brokerage name still must appear. Nicknames, street addresses, and logos do not replace the required brokerage identification. Question 3. When Casey Wilson buys a condominium unit in Stillwater, what does the buyer typically own? Option A. Only a stock certificate and no real property interest. Option B. The entire building in severalty. Option C. The individual unit plus an undivided interest in the common elements. Option D. A temporary license to occupy the unit. The correct answer is option C. The individual unit plus an undivided interest in the common elements. Condominium ownership generally includes the individual unit and an undivided interest in common elements. A cooperative usually involves shares and a proprietary lease, not condominium ownership. The buyer does not own the whole building alone or merely hold a temporary license. Question 4. A broker compares a buyer's desired use with zoning rules, parcel size, and market demand. What appraisal principle is being considered for Drew in Eden Prairie involving a vacant lot priced at $447,500? Option A. Tie-in arrangement. Option B. Novation. Option C. Steering. Option D. Highest and best use. The correct answer is option D. Highest and best use. Highest and best use evaluates legal permissibility, physical possibility, financial feasibility, and maximum productivity. Tie-in arrangements, novation, and steering involve antitrust, contract substitution, and fair housing concerns. The analysis is about the most supportable property use. Question 5. A tenant with a disability asks for an assigned accessible parking space near the entrance. What fair housing concept is most directly involved for Reese and Bemidji involving a condominium unit priced at $296,000? Option A. Reasonable accommodation. Option B. Adverse possession. Option C. Yield spread premium. Option D. Defeasance clause. The correct answer is option A. Reasonable accommodation. A reasonable accommodation is a change in rules, policies, or services that may be needed for a person with a disability to use and enjoy housing. Adverse possession concerns ownership claims, yield spread premiums concern loan compensation, and defeasance clauses concern loan satisfaction. The requested parking change involves access to housing. Question 6. An appraiser adjusts comparable sales for differences from the subject property. Which approach is being applied for Emerson in Edina involving a single-family home priced at $375,000? Option A. Cost approach only. Option B. Sales comparison approach. Option C. Income approach only. Option D. Mortgage registry method. The correct answer is option B. Sales comparison approach. The sales comparison approach compares the subject to similar sold properties and adjusts for differences. Cost and income approaches use different inputs, and mortgage registry tax is not an appraisal method. Comparable sale adjustment is a core valuation technique. Question 7. Why might Harper Okafor use a quitclaim deed to clear a possible title issue? Option A. It guarantees the property is free of every lien. Option B. It creates a new mortgage automatically. Option C. It transfers whatever interest the grantor may have without making title warranties. Option D. It replaces the need for delivery and acceptance. The correct answer is option C. It transfers whatever interest the grantor may have without making title warranties. A quitclaim deed can release or transfer any interest the grantor may have, but it does not warrant title quality. It does not guarantee lien-free ownership or create a mortgage. Like other deeds, it still depends on proper execution, delivery, and acceptance. Question 8. A built-in dishwasher is attached and adapted to a duplex. What is it most likely considered in a sale? Option A. Emblement. Option B. Trade name. Option C. License. Option D. Fixture. The correct answer is option D. Fixture. A fixture is personal property that has become real property through attachment, adaptation, intent, or agreement. Emblements are crops, a trade name is business identity, and a license is permission. Built-in appliances are commonly analyzed as fixtures. Question 9. Which deed gives Rowan Peterson the broadest set of title warranties from the grantor? Option A. General warranty deed. Option B. Quitclaim deed. Option C. Bargain and sale deed with no covenants. Option D. Tax certificate only. The correct answer is option A. General warranty deed. A general warranty deed provides the strongest customary covenants of title from the grantor. A quitclaim deed conveys whatever interest the grantor has without warranties. A bargain and sale deed without covenants and a tax certificate provide less assurance than a general warranty deed. Question 10. Under federal fair housing law, which group is a protected class in the sale or rental of housing for Reese and Bemidji involving a condominium unit priced at $281,500? Option A. Credit score above 700. Option B. Familial status. Option C. Preference for lakefront homes. Option D. Employment in real estate sales. The correct answer is option B. Familial status. Familial status is a protected class under federal fair housing law. Credit score, housing preferences, and occupation in real estate are not protected classes by themselves. Housing decisions must avoid discrimination based on protected characteristics. Question 11. While interviewing with two firms in Duluth, Riley asks how many Minnesota brokers may supervise the salesperson during the same period. Option A. 2 brokers if both brokers consent. Option B. Any number of brokers if the salesperson discloses the arrangement. Option C. 1 actively licensed broker. Option D. 1 broker for residential sales and a separate broker for leases. The correct answer is option C. 1 actively licensed broker. A salesperson in Minnesota is licensed to act on behalf of 1 broker during the same period. Consent or disclosure does not create authority to work under multiple brokers. Splitting residential and leasing work between brokers would still violate the Single Broker Association rule. Question 12. A seller says the basement is perfectly dry despite knowing of repeated water intrusion. Why is that more than ordinary puffing for Harper and Blaine involving a newly built townhouse priced at $228,500? Option A. It is always protected opinion regardless of knowledge. Option B. It is allowed if the buyer gets a loan. Option C. It becomes legal if stated verbally instead of in writing. Option D. It is a factual misrepresentation about a material property condition. The correct answer is option D. It is a factual misrepresentation about a material property condition. A specific false statement about a known material condition can be misrepresentation. Puffing is general opinion, not a false factual claim about water problems. Financing approval or verbal delivery does not make a known material misstatement acceptable. Question 13. In appraisal, what does highest and best use require for Riley and Bloomington involving a condominium unit priced at $357,500? Option A. A use that is legally permissible, physically possible, financially feasible, and maximally productive. Option B. The use that produces the highest commission. Option C. The use preferred by the current tenant only. Option D. The use with the lowest property tax bill. The correct answer is option A. A use that is legally permissible, physically possible, financially feasible, and maximally productive. Highest and best use considers legal, physical, financial, and productivity tests. Commission, tenant preference, and tax savings alone do not determine highest and best use. The concept focuses on the most supportable use of the property as real estate. Question 14. A broker tells competing firms to keep commissions at the same percentage in Egan. What legal risk is most obvious? Option A. Accretion. Option B. Price fixing under antitrust law. Option C. Constructive eviction. Option D. Functional obsolescence. The correct answer is option B. Price fixing under antitrust law. Competitors agreeing on commission rates can be price fixing, an antitrust violation. Accretion, constructive eviction, and functional obsolescence involve land change, landlord-tenant issues, and valuation. Commissions must be independently negotiated, not fixed by competitors. Question 15. If assessed value is $250,325 and the tax rate is 25 mils, what is the annual property tax? Option A. $1,288. Option B. $4,418. Option C. $6,258. Option D. $73,625. The correct answer is option C. $6,258. A mil is $1 per $1,000 of assessed value, so the tax is assessed value multiplied by mils divided by 1,000. Monthly interest, points, and down payment are financing calculations. Millage questions require converting mils to a decimal rate. Question 16. For Blair Patel's first real estate job in Bloomington, who submits the Minnesota salesperson license application after the applicant becomes associated with a broker? Option A. The applicant directly through a personal account only. Option B. The listing client from the applicant's first transaction. Option C. The county recorder in the county where the applicant lives. Option D. The licensed real estate broker with whom the applicant is associated. The correct answer is option D. The licensed real estate broker with whom the applicant is associated. A Minnesota salesperson must be associated with a licensed broker, and the broker submits the license application. The applicant alone does not file the salesperson application, clients have no filing role, and county recorders do not issue salesperson licenses. Broker sponsorship is central to salesperson licensure. Question 17. If a seller rejects Jordan Thompson's offer and the listing broker holds the earnest money, when should the rejected offer's earnest money be returned? Option A. No later than the next business day after rejection. Option B. Only after the seller signs a different purchase agreement. Option C. At the end of the listing period. Option D. After the broker deducts marketing expenses. The correct answer is option A. No later than the next business day after rejection. When an offer is rejected, Minnesota trust account rules require earnest money to be returned to the potential buyer no later than the next business day after rejection. The broker cannot hold it until another sale, listing expiration, or reimbursement of marketing costs. Rejected offers do not create a right to keep the buyer's funds. Question 18. A buyer includes an inspection condition in a St. Paul purchase agreement. What is the role of that contingency? Option A. It automatically transfers title to the buyer. Option B. It makes the buyer's duty to perform depend on the stated inspection condition being satisfied or waived. Option C. It eliminates the need for earnest money accounting. Option D. It makes the broker a home inspector. The correct answer is option B. It makes the buyer's duty to perform depend on the stated inspection condition being satisfied or waived. A contingency is a condition that must be satisfied, waived, or otherwise resolved for the contract obligations to proceed as written. It does not transfer title or remove trust accounting duties. The broker does not become the inspector merely because the contract contains an inspection contingency. Question 19. A garage built on Parker Peterson's land extends 2 feet over the boundary onto a neighbor's parcel. What issue is created? Option A, hypothecation. Option B, subrogation. Option C, encroachment. Option D, reconciliation. The correct answer is option C, encroachment. An encroachment occurs when an improvement physically intrudes onto another parcel. Hypothecation pledges property for debt, subrogation substitutes one party's claim, and reconciliation is an appraisal conclusion step. The garage crossing the boundary is the key fact. Question 20. After passing the examination, Emerson wants to submit a Minnesota salesperson license application immediately. Which education requirement still must be met before applying? Option A. Only course I is ever required for the license. Option B. A broker's 30-hour course must replace course 3. Option C. No additional education is needed once the exam is passed. Option D. Courses 2 and 3 must be successfully completed if they have not already been completed. The correct answer is option D. Courses 2 and 3 must be successfully completed if they have not already been completed. Course I opens exam eligibility, but courses 2 and 3 must be completed before the salesperson license application. Passing the exam does not erase the remaining pre-license education requirement. The other options either omit required courses or invent a broker-only replacement course. Question 21. A Northfield salesperson wants to place personal money in the broker trust account to save for taxes. Why is that improper? Option A. Trust accounts may contain only trust funds except limited identified funds for service charges or minimum balance requirements. Option B. Personal funds must always be kept in the listing broker's trust account. Option C. Salespersons may use trust accounts as savings accounts with broker consent. Option D. Commingling is allowed when the amount is less than 1 month's rent. The correct answer is option A. Trust accounts may contain only trust funds except limited identified funds for service charges or minimum balance requirements. Trust accounts are for trust funds, with only limited identified personal funds allowed for service charges or minimum balance requirements. Using the account as a personal savings account would commingle funds. Broker consent or a small amount does not change the commingling rule. Question 22. A buyer agrees with the lender to become personally liable on the seller's existing mortgage. What is the buyer doing for Casey in Mankato involving a single-family home priced at $462,000? Option A. Taking subject to the mortgage only. Option B. Assuming the mortgage. Option C. Creating an easement appurtenant. Option D. Paying deed tax only. The correct answer is option B. Assuming the mortgage. Mortgage assumption involves the buyer taking personal responsibility for the existing loan obligation with lender involvement. Taking subject to a mortgage lacks personal liability to the lender. Easements and deed taxes do not describe assuming debt. Question 23. A parcel borders a non-navigable stream. Rights connected to that water are commonly called what for Parker in Moorhead involving a duplex priced at $443,000? Option A. Literal rights only. Option B. Emblement rights. Option C. Riparian rights. Option D is subrogation rights. The correct answer is option C. Riparian rights. Riparian rights relate to land adjoining rivers or streams. Literal rights are associated with lakes and other large bodies of water, while emblements and subrogation are different concepts. Water-adjacent property rights are common ownership questions. Question 24. Which document is used to convey ownership of real property from grantor to grantee for Jordan in Duluth involving a vacant lot priced at $244,000? Option A. Promissory note. Option B. Listing presentation. Option C. Home inspection checklist. Option D. Deed. The correct answer is option D. Deed. A deed is the instrument used to convey title from grantor to grantee. A promissory note creates a debt promise, a listing presentation markets services, and an inspection checklist reports property condition. Conveyance and financing documents have different functions. Question 25. If annual property taxes of $2,750 are prorated to the seller for 108 days on a 365-day basis, approximately what amount is charged to the seller? Option A, $814. Option B, $14,138. Option C, $1,958. Option D, $1,060. The correct answer is option A, $814. Tax proration divides the annual tax by 365 and multiplies by the number of seller days. Commission, discount points, and monthly interest are unrelated calculations. Proration allocates an annual expense fairly between buyer and seller at closing. Question 26. A deed gives Drew possession for life, then ownership passes to Casey Patel. What interest does Casey Patel hold before Drew's death? Option A, leasehold estate. Option B, remainder interest. Option C, easement in gross. Option D, mortgage lien. The correct answer is option B, remainder interest. A remainder interest is a future interest that becomes possessory after a life estate ends. A leasehold is a tenant's possession, an easement in gross is a use right, and a mortgage lien secures debt. The buyer's right follows the life tenant's measuring life. Question 27. A buyer brings certified funds for price, closing costs, and prepaid items after lender credits are applied. What is this amount commonly called for Drew in Eden Prairie involving a condominium unit priced at $382,500? Option A, gross rent multiplier. Option B, a functional obsolescence. Option C, cash to close. Option D, protective list. The correct answer is option C, cash to close. Cash to close is the amount the buyer must bring to complete the transaction after credits, loan proceeds, and closing charges are calculated. GRM is an appraisal shortcut, functional obsolescence is depreciation, and a protective list relates to override clauses. The question is about closing settlement funds. Question 28. At Capital City Realty, a salesperson asks which online system the Commerce Department uses for many licensing services such as applications, renewals, and transfers. Option A, MLS Grid. Option B, Torrens Online. Option C, HUD Exchange. Option D, Pulse. The correct answer is option D, Pulse. Pulse is the electronic licensing system used for many Minnesota Commerce Department licensing services. MLS systems, Torrens records, and HUD resources serve different purposes. Knowing the licensing portal helps distinguish administrative filing from transaction records and federal housing resources. Question 29. If Parker Kahn pays interest only for the first month on a $339,000 loan at 6%, approximately what is 1 month's interest? Option A, $1,695. Option B, $6,780. Option C, $3,353. Option D, $31,850. The correct answer is option A, $1,695. Monthly interest is calculated by multiplying the loan balance by the annual rate and dividing by 12. Points, tax proration, and front foot value use different formulas and bases. Interest calculations test careful conversion from annual to monthly rates. Question 30. Before advertising Hayden Davis's fourplex to the general public, what must a Minnesota licensee obtain? Option A, an oral promise that the owner may list later. Option B, a signed listing agreement or other signed written authorization from the owner or authorized person. Option C, a buyer's pre-approval letter. Option D, a tax parcel map from the county. The correct answer is option B, a signed listing agreement or other signed written authorization from the owner or authorized person. A licensee must have a signed listing agreement or other signed written authorization before advertising real property for sale or lease to the general public. Oral permission is not enough for this requirement. Buyer pre-approval and tax maps may be useful, but they do not authorize public advertising. Question 31. At closing, Why are prepaid property taxes or rents commonly prorated between buyer and seller for Quinn in Woodbury involving a single-family home priced at $469,000? Option A. To change the sales price after acceptance. Option B. To avoid recording the deed. Option C. To allocate income or expenses to the party who owned the property during the relevant time period. Option D. To eliminate the need for title insurance. The correct answer is option C. To allocate income or expenses to the party who owned the property during the relevant time period. Prorations allocate recurring income and expenses based on the period each party is entitled to or responsible for them. They do not rewrite the price, avoid recording, or replace title insurance. Closing statements use debits and credits to make this allocation. Question 32. When Finley, a licensee, intends to buy a client's property in Red Wing, what disclosure is required before negotiation or consummation? Option A. The licensee may stay silent if paying full market value. Option B. The disclosure is needed only after the deed is recorded. Option C. Only the buyer's lender must be told about the license. Option D. The licensee must affirmatively disclose the license status and the capacity in which the licensee is acting. The correct answer is option D. The licensee must affirmatively disclose the license status and the capacity in which the licensee is acting. A Minnesota licensee who acquires or intends to acquire an interest in real property must disclose the license status and capacity before negotiation or consummation. Paying market value does not remove the conflict risk, and post-recording disclosure would be too late. Lender-only notice does not satisfy disclosure to the property owner. Question 33. If a Eden Prairie property sells for $261,000 and the buyer obtains an 70% loan, what is the buyer's down payment? Option A, $78,300. Option B, $182,700. Option C, $15,660. Option D, $2,463. The correct answer is option A, $78,300. The down payment is the sale price minus the loan amount. The loan amount is the financed portion, the commission is a brokerage compensation calculation, and the tax proration allocates property taxes. Separating buyer equity from loan proceeds is a core exam math skill. Question 34. Under the Minnesota Human Rights Act, which protected basis expands beyond the traditional federal fair housing list for Cameron and Brainerd involving a townhome priced at $372,500? Option A, preference for a short commute. Option B, status with regard to public assistance. Option C, owning two vehicles. Option D, having a fixed-rate mortgage. The correct answer is option B, status with regard to public assistance. Minnesota housing and real property discrimination law includes status with regard to public assistance among protected bases. Commute preference, vehicle ownership, and mortgage type are not protected classes. State law can add protections beyond the federal baseline. Question 35. Which Minnesota tax is generally associated with recording a mortgage that secures debt on real property for Hayden in Maple Grove involving a fourplex priced at $211,000? Option A, personal income withholding tax. Option B, sales tax on furniture. Option C, mortgage registry tax. Option D, special assessment appeal fee. The correct answer is option C, mortgage registry tax. Mortgage registry tax is tied to the recording of a mortgage securing debt. Personal income withholding, furniture sales tax, and assessment appeals are different issues. The exam often distinguishes mortgage registry tax from deed tax. Question 36. A rumor says a Blaine home was once the site of a natural death and possible paranormal activity. Under Minnesota disclosure rules, how is that fact treated? Option A. It must always be disclosed in the listing contract. Option B. It makes the property unmarketable until court approval. Option C. It requires the buyer to receive a separate environmental report. Option D. It is not treated as a material fact that must be disclosed merely for that reason. The correct answer is option D. It is not treated as a material fact that must be disclosed merely for that reason. Minnesota law states that certain stigmatizing facts, such as suicide, natural death, or perceived paranormal activity, are not material facts requiring disclosure merely because they occurred. That does not change the duty to disclose physical defects or other material facts. Listing contracts, court approval, and environmental reports address different issues. Question 37. Which event usually allows trust funds in a Minnesota real estate transaction to be disbursed for Blair and Red Wing involving a lake cabin priced at $330,500? Option A, closing of the transaction, written agreement of the parties, statutory affidavit, or court order. Option B, a verbal request from one salesperson. Option C, a social media announcement that the deal is done. Option D, the buyers hope to renegotiate after closing. The correct answer is option A, closing of the transaction, written agreement of the parties, statutory affidavit, or court order. Trust funds may be disbursed only under recognized authority such as closing, written agreement, applicable statutory affidavit, or court order. A verbal request or social media post does not provide the necessary authority. A buyer's later wish to renegotiate is not a trust fund disbursement event. Question 38. A homestead classification question appears on a Minnesota practice exam. What topic is being tested most directly for Rowan in Stillwater involving a vacant lot priced at $219,000? Option A, federal lead paint pamphlet rules only. Option B, property tax and ownership status treatment. Option C, advertising font size only. Option D, dual agency consent wording only. The correct answer is option B, property tax and ownership status treatment. Homestead classification generally relates to property tax and ownership or occupancy status. Lead paint, advertising, and dual agency are separate real estate topics. Exam questions may connect homestead status with tax treatment and ownership rights. Question 39. If Finley Lee tells the licensee that the seller will not perform under the signed purchase agreement, what must the licensee do? Option A, keep the information confidential until the closing date. Option B, cancel the agreement without telling the buyer. Option C, immediately disclose the stated intent not to perform to the other party or parties. Option D, disclose only if the seller misses a loan contingency. The correct answer is option C, immediately disclose the stated intent not to perform to the other party or parties. A licensee put on notice that a party will not perform according to the transaction agreement must disclose that intent to the other party or parties. Keeping the information secret would mislead the other side. The rule is different from a party's inability to satisfy a contingency. Question 40. A deed expressly creates survivorship between co-owners of a condominium unit. Which ownership feature is being emphasized? Option A, no right to possess the property. Option B, a tenant's trade fixture right. Option C, a mortgagee's foreclosure priority. Option D, right of survivorship in joint tenancy. The correct answer is option D, right of survivorship in joint tenancy. Joint tenancy is associated with right of survivorship when properly created. Co-owners generally have possession rights, and trade fixtures concern tenants rather than co-owner succession. Mortgage priority is a lien issue, not survivorship ownership. Question 41. A rental property produces $63,500 in net operating income and investors require a 7.5% capitalization rate. What value is indicated by the income approach? Option A, $846,667. Option B, $237,000. Option C, $298,125. Option D, $54,050. The correct answer is option A, $846,667. The income approach using direct capitalization divides net operating income by the capitalization rate. Gross rent multiplier, loan amount, and frontage calculations use different inputs. The cap rate converts expected net income into an indicated value. Question 42. Why should a purchase agreement for a farm parcel in Stillwater be in writing and signed by the party to be charged? Option A. All oral contracts are criminal offenses. Option B. The statute of frauds requires most real estate sale contracts to be in writing to be enforceable. Option C. Only lenders may sign real estate contracts. Option D. A deed is unnecessary if the parties shake hands. The correct answer is option B. The statute of frauds requires most real estate sale contracts to be in writing to be enforceable. The statute of frauds generally requires contracts for the sale of real property to be in writing and signed by the party to be charged. Oral agreements may fail enforceability even if the parties intended a deal. Lender-only signatures and handshake transfers do not replace the required written contract and later conveyance documents. Question 43. A neighbor receives permission to park on Jordan Chen's land for one weekend only. What interest is most likely created? Option A. Easement appurtenant. Option B. Fee simple estate. Option C. License. Option D. A mechanic's lien. The correct answer is option C. License. A license is personal permission to use property and is generally revocable. An easement appurtenant is a more durable interest tied to benefited land. Fee simple is ownership, and a mechanic's lien secures payment. Temporary parking permission is a license. Question 44. Which appraisal approach is usually most persuasive for a typical owner-occupied home in a subdivision with many recent comparable sales for Cameron and Brainerd involving a small retail building priced at $288,000? Option A. Cost approach only. Option B. Income approach only. Option C. Front foot method only. Option D. Sales comparison approach. The correct answer is option D. Sales comparison approach. The sales comparison approach is usually strongest when similar properties have sold recently in the same market. The cost approach can be useful for new or special purpose improvements, and the income approach is more relevant to income-producing property. Front foot analysis is a land valuation tool, not the main method for a typical home. Question 45. If one broker represents both Finley Garcia and Rowan Peterson in a residential transaction, what must occur before the broker acts as a dual agent? Option A. All parties must give informed consent to the dual agency relationship. Option B. Only the seller must consent because the seller listed the property. Option C. The broker may proceed without consent if the commission is reduced. Option D. Consent is unnecessary if two different salespersons are involved. The correct answer is option A. All parties must give informed consent to the dual agency relationship. Dual agency requires informed consent from the parties because the broker owes duties to both sides and cannot advocate exclusively for either one. A lower commission does not remove the conflict, and two salespersons licensed to the same broker can still create dual agency. Seller-only consent is not enough. Question 46. A licensee in Edina drafts a complex legal clause for Jordan and Gwynn instead of recommending legal counsel. What risk is created? Option A. Constructive eviction. Option B. Unauthorized practice of law. Option C. Functional obsolescence. Option D. Inverse condemnation. The correct answer is option B. Unauthorized practice of law. Licensees may fill in approved forms and explain business terms, but drafting legal clauses can cross into unauthorized practice of law. Constructive eviction, functional obsolescence, and inverse condemnation describe different legal or valuation issues. Complex legal drafting should be handled by an attorney. Question 47. A lender draws a line around a Carver neighborhood and refuses otherwise qualified mortgage applicants there. What fair housing and lending term best fits? Option A. Plottage. Option B. Accretion. Option C. Redlining. Option D. Estoppel. The correct answer is option C. Redlining. Redlining is denying or limiting credit in an area for discriminatory reasons rather than evaluating individual qualifications. Plottage relates to value from assemblage, accretion is natural land buildup, and estoppel prevents inconsistent claims. Area-based discriminatory lending violates fair lending principles. Question 48. Why would an appraiser rely heavily on the cost approach for a newly built vacant lot in Eden Prairie? Option A. It ignores land value completely. Option B. It is the only legal method for all residential property. Option C. It values the property only by monthly rent. Option D. Replacement cost and depreciation can be estimated more reliably for new improvements. The correct answer is option D. Replacement cost and depreciation can be estimated more reliably for new improvements. The cost approach is useful for new construction because replacement cost and accrued depreciation can be estimated with less uncertainty. It still includes land value and is not the only legal method for every property. Monthly rent belongs to income analysis rather than cost analysis. Question 49. A buyer takes title while the seller's existing loan remains in place, but the buyer does not become personally liable to the lender. What phrase best describes this for Reese and Bemidji involving a condominium unit priced at $223,500? Option A. Taking subject to the mortgage. Option B. Assuming the mortgage with release. Option C. Creating a life estate. Option D. Recording a quitclaim covenant. The correct answer is option A. Taking subject to the mortgage. Taking subject to a mortgage means the property remains security for the debt, but the buyer does not personally promise the lender to pay. Assumption involves personal liability unless otherwise released. Life estates and quitclaim covenants are unrelated to this financing arrangement. Question 50. If Taylor passes the salesperson examination on a spring test date, how long does the candidate generally have to apply for the license before retaking the exam is required? Option A. 30 days from passing the examination. Option B. 1 year from passing the examination. Option C. 3 years from passing the examination. Option D. Until the next broker renewal cycle only. The correct answer is option B. 1 year from passing the examination. Minnesota guidance states that the salesperson license application must be made within 1 year after passing the examination. Shorter periods such as 30 days are too restrictive, and longer periods ignore the retake requirement. The broker renewal cycle does not control the candidate's examination validity period. Question 51. Unless the parties' written agreement says otherwise, when should a Minnesota listing broker deposit earnest money after receiving it and final acceptance has occurred for Avery in Eagan involving a townhome priced at $228,000? Option A. Only after the buyer's loan is fully underwritten. Option B. At any time before the deed is recorded. Option C. Within 3 business days of receipt or final acceptance, whichever is later. Option D. Within 30 calendar days after the first showing. The correct answer is option C. Within 3 business days of receipt or final acceptance, whichever is later. Minnesota trust account rules provide a default deadline of 3 business days after receipt or final acceptance, whichever is later, when the written agreement is silent. Waiting for underwriting, recording, or an arbitrary 30-day period would not meet that default rule. The parties can address timing in their written agreement. Question 52. A lender offers Morgan Lee a mortgage whose interest rate can change based on an index after an initial period. What type of loan is this? Option A. Package mortgage only. Option B. Open-end listing. Option C. Graduated lease. Option D. Adjustable rate mortgage. The correct answer is option D. Adjustable rate mortgage. An adjustable rate mortgage has an interest rate that may change according to an index and loan terms. A package mortgage includes personal property, an open-end listing is not a standard listing type, and a graduated lease changes rent over time. The index-based interest change identifies the loan type. Question 53. A buyer pays 1% in discount points on a $220,500 loan. Approximately how much are the points? Option A. $2,205. Option B. $1,102. Option C. $24,500. Option D. $13,475. The correct answer is option A. $2,205. 1 discount point equals 1% of the loan amount, so the points are calculated by multiplying the loan amount by the point percentage. Monthly interest, down payment, and commission are calculated from different formulas. The point charge is a loan cost calculation, not a sales commission or equity contribution. Question 54. A zoning ordinance limits building height in Rochester. What government power is most directly involved? Option A, eminent domain. Option B, police power. Option C, this cheat. Option D, taxation only. The correct answer is option B, police power. Police power allows government to regulate property use for health, safety, morals, and general welfare. Eminent domain is taking for public use, escheat handles ownerless property, and taxation raises revenue. Zoning is a classic police power regulation. Question 55. A broker learns that a foundation defect could significantly affect Avery Garcia's use of a duplex in Northfield. What should the broker do? Option A, stay silent because the defect might reduce the seller's price. Option B, disclose only after closing if the buyer complains. Option C, disclose the material fact to the prospective purchaser. Option D, treat the defect as confidential even if it affects use and enjoyment. The correct answer is option C, disclose the material fact to the prospective purchaser. Known material facts that could adversely and significantly affect an ordinary buyer's use or enjoyment must be disclosed. Protecting a sale price does not excuse non-disclosure, and waiting until after closing defeats the purpose of the rule. Confidentiality does not cover facts that law requires to be disclosed. Question 56. Under Minnesota law, which statute is the primary source for real estate broker and salesperson regulation for Drew and Eden Prairie involving a vacant lot priced at $428,500? Option A, Minnesota Statutes Chapter 287 only. Option B, the Federal Internal Revenue Code only. Option C, a local MLS policy manual only. Option D, Minnesota Statutes Chapter 82. The correct answer is option D, Minnesota Statutes Chapter 82. Chapter 82 governs real estate brokers and salespersons in Minnesota. Chapter 287 covers deed tax and mortgage registry tax topics, and federal tax law or MLS policies do not replace state licensing law. Exam questions often test which authority controls licensing conduct. Question 57. Before Quinn schedules the salesperson examination after studying in Mankato, which pre-license course must already be completed? Option A, Course I. Option B, Course 2 only. Option C, Course 3 only. Option D, the annual continuing education module. The correct answer is option A, Course I. Course I must be successfully completed before a candidate registers for the salesperson examination. Course 2 and Course 3 are required before license application, while the annual module is a continuing education requirement for licensees. Confusing pre-license and continuing education rules leads to the wrong result. Question 58. Two brokerages agree that one will work only north of Edina and the other only south. What antitrust violation may this suggest? Option A, redemption. Option B, a market allocation. Option C, assemblage. Option D is subrogation. The correct answer is option B, market allocation. Market allocation occurs when competitors divide customers or territories instead of competing. Redemption, assemblage, and subrogation are unrelated real estate concepts. Geographic division by competing brokerages creates serious antitrust risk. Question 59. A borrower signs a promissory note and mortgage to finance a Blaine home. What does the note do? Option A, transfers title to the lender at closing. Option B, sets the zoning classification. Option C, creates the borrower's personal promise to repay the debt. Option D, records the deed tax payment. The correct answer is option C, creates the borrower's personal promise to repay the debt. The promissory note is the borrower's promise to repay according to the loan terms. The mortgage secures that promise with a lien on the property. Zoning, title transfer, and deed tax are separate matters. Question 60. A property owner dies with no will and no heirs. What government power may transfer the property to the state for Emerson in Edina involving a mixed-use property priced at $350,000? Option A, eminent domain. Option B, literal rights. Option C, subordination. Option D, escheat. The correct answer is option D, escheat. Escheat transfers property to the state when an owner dies without a will and without heirs. Eminent domain involves compensated taking, literal rights involve water, and subordination changes lien priority. The absence of heirs is the clue. Question 61. At closing, a seller debit for unpaid property taxes usually means what for Reese and Bemidji involving a farm parcel priced at $426,000? Option A. The seller is being charged for the portion owed for the seller's period of ownership. Option B. The buyer is paying the seller's commission twice. Option C. The lender has forgiven the loan. Option D. The deed has failed to convey title. The correct answer is option A. The seller is being charged for the portion owed for the seller's period of ownership. A seller debit reduces the seller's proceeds for an amount the seller owes, such as the seller's share of property taxes. It does not double a commission, forgive a loan, or prove the deed failed. Debits and credits allocate amounts between the parties. Question 62. An appraiser subtracts curable physical deterioration and functional obsolescence from replacement cost. Which approach is being used for Avery in Egan involving a small retail building priced at $242,500? Option A, sales comparison approach only. Option B, cost approach. Option C, income approach only. Option D, gross rent multiplier only. The correct answer is option B, cost approach. The cost approach estimates land value plus improvement cost minus depreciation. Sales comparison relies on comparable sales, and income analysis capitalizes income. Depreciation from replacement cost is the clue. Question 63. A licensee directs families with children only toward one area of St. Cloud. What fair housing problem does that conduct create for Morgan in St. Cloud involving a rental house priced at $268,500? Option A, amortization. Option B, subordination. Option C, steering. Option D, novation. The correct answer is option C, steering. Steering occurs when a real estate professional guides prospects toward or away from areas based on a protected characteristic. Amortization is loan repayment, subordination is lien priority adjustment, and novation is contract substitution. The conduct described limits housing choice and raises fair housing risk. Question 64. A sudden flood removes soil from a riverbank in Clay County. What term describes the sudden loss? Option A, accretion. Option B, assemblage. Option C, plottage. Option D, divulsion. The correct answer is option D, avulsion. Avulsion is sudden loss or change of land by natural forces. Accretion is gradual buildup, assemblage combines parcels, and plottage is the value increase from assemblage. The word sudden distinguishes avulsion. Question 65. A property use existed legally before a zoning change and may continue despite the new rule. What is it called for Harper and Blaine involving a townhome priced at $303,000? Option A, legal non-conforming use. Option B, blockbusting. Option C, estoppel certificate. Option D, defeasible fee only. The correct answer is option A, legal non-conforming use. A legal non-conforming use lawfully existed before a zoning change and is often allowed to continue under limits. Blockbusting is a fair housing violation, estoppel certificates relate to leases or representations, and defeasible fee is an ownership estate. The timing before the zoning change is key. Question 66. A licensee exaggerates by saying a backyard view is the best sunset in Minnesota. How is that usually classified for Casey and Mankato involving a mixed-use property priced at $459,000? Option A, a guaranteed appraisal. Option B, puffing if it is clearly opinion rather than a factual claim. Option C, a material title defect. Option D, a deed restriction. The correct answer is option B, Puffing if it is clearly opinion rather than a factual claim. Puffing is an opinion or sales statement that a reasonable person would not treat as a factual guarantee. It differs from misrepresenting a known defect or title issue. The sunset statement is subjective unless tied to a specific false fact. Question 67. A Moorhead buyer's loan has small monthly payments but one large final payment. What is that final payment called? Option A, proration credit. Option B, replacement reserve. Option C, a balloon payment. Option D, equity dividend. The correct answer is option C, balloon payment. A balloon payment is a large unpaid balance due at the end of a loan term. A proration credit divides expenses at closing, a replacement reserve funds future repairs, and an equity dividend is an investment return measure. The structure described is a financing feature. Question 68. Recording a deed for a duplex in Olmsted County primarily gives what type of notice to the public? Option A, private notice only to the buyer's lender. Option B, a zoning variance. Option C, a guarantee of physical condition. Option D, constructive notice. The correct answer is option D, constructive notice. Recording places an instrument in the public records and gives constructive notice of the recorded interest. It does not create a zoning variance or guarantee the property's physical condition. The public records system protects priority and notice, not building quality. Question 69. A legal description refers to township, range, and section. Which survey system is being used for Sawyer in Winona involving a small retail building priced at $187,500? Option A, rectangular government survey system. Option B, meets and bounds only. Option C, lot and block only. Option D, a gross lease system. The correct answer is option A, rectangular government survey system. The rectangular government survey system uses townships, ranges, and sections. Meets and bounds relies on boundary calls, and lot and block relies on subdivision plats. Gross lease is a lease structure, not a land description system. Question 70. A salesperson tells owners in Maple Grove to sell quickly because people from a protected class are moving nearby. What prohibited practice does this describe for Hayden in Maple Grove involving a fourplex priced at $411,000? Option A, reconciliation. Option B, blockbusting. Option C, hypothecation. Option D, assemblage. The correct answer is option B, blockbusting. Blockbusting uses fear or panic about protected class changes to induce owners to sell or rent. Reconciliation is an appraisal step, hypothecation pledges property as loan security, and assemblage combines parcels. The key issue is discriminatory pressure on owners. Question 71. Two investors own a Minneapolis duplex with unequal shares and no survivorship language. Which ownership form is most likely? Option A, tenancy by the entirety. Option B, severalty. Option C, tenancy in common. Option D, life tenancy only. The correct answer is option C, tenancy in common. Tenancy in common allows unequal ownership shares and has no automatic right of survivorship. Severalty means one owner, and a life tenancy is measured by a life. Tenancy by the entirety is a special marital form not described by unequal investor shares. Question 72. A zoning board permits a property use that otherwise violates strict zoning because of unique hardship. What relief is typically granted for Morgan and St. Cloud involving a rental house priced at $290,500? Option A, certificate of title. Option B, quitclaim covenant. Option C, mortgage assumption. Option D, variance. The correct answer is option D, variance. A variance provides relief from strict zoning requirements when legal standards are met, often involving unique hardship. Certificates of title, quitclaim deeds, and mortgage assumptions do not authorize zoning deviations. Land use approval is the issue. Question 73. Gradual soil buildup along a stream increases a parcel's size. What term best fits for Jordan in Duluth involving a vacant lot priced at $401,500? Option A, accretion. Option B, divulsion. Option C, condemnation. Option D, defeasance. The correct answer is option A, accretion. Accretion is gradual addition of land through natural forces. Avulsion is sudden change, condemnation is taking by eminent domain, and defeasance concerns loan satisfaction. Gradual buildup is the key clue. Question 74. Under Chapter 82 Standards, what must a broker do to properly supervise salespersons at a Minneapolis office? Option A. Let each salesperson approve their own contracts without broker review. Option B. Monitor brokerage activities, review transaction documents, and review trust account books and records. Option C. Delegate all trust records to buyers and sellers. Option D. Supervise only advertising and ignore purchase agreements. The correct answer is option B. Monitor brokerage activities, review transaction documents, and review trust account books and records. Broker supervision includes ongoing monitoring of salespersons, transaction documents, and trust account records. Salespersons do not self-supervise, and clients are not responsible for brokerage trust accounting. Limiting supervision to advertising would miss major broker responsibilities. Question 75. A licensee in Woodbury wants to know which required continuing education topics must be included in the renewal cycle along with the general module. Option A. Only appraisal theory and mortgage underwriting. Option B. Only property insurance and income tax preparation. Option C. Agency law and fair housing. Option D. Only construction codes and zoning administration. The correct answer is option C. Agency law and fair housing. Minnesota renewal requirements include agency representation and disclosure training and fair housing training as part of the required education mix. Appraisal, insurance, tax, construction, and zoning topics may be useful, but they do not replace those mandated topics. The rule is designed to keep licensees current on representation and anti-discrimination duties. Question 76. During a first substantive contact with a residential consumer in Maple Grove, what disclosure should the licensee provide? Option A. A final closing disclosure showing loan terms. Option B. A county tax statement for the current year. Option C. A deed prepared for recording. Option D. An agency disclosure form explaining available agency and facilitator relationships. The correct answer is option D. An agency disclosure form explaining available agency and facilitator relationships. Minnesota requires an agency disclosure form at the first substantive contact in residential transactions covered by the statute. The form explains representation choices and facilitator status before the consumer decides whether to enter a representation contract. Closing disclosures, tax statements, and deeds serve different functions later in the transaction. Question 77. A title search finds an unpaid mechanics lien recorded against a Edina property. Why does this matter to a buyer? Option A. It may be an encumbrance affecting title and closing requirements. Option B. It proves the buyer has already paid cash. Option C. It automatically creates a condominium. Option D. It removes all property taxes. The correct answer is option A. It may be an encumbrance affecting title and closing requirements. A mechanics lien can encumber title and may need to be resolved before or at closing. It does not prove cash payment, create condominium ownership, or remove tax obligations. Title review identifies recorded claims that may affect ownership. Question 78. A listing agreement for a Bloomington seller is missing a definite end date. Why is that a licensing problem? Option A. Listing agreements are valid only if they renew forever. Option B. Minnesota listing agreements must include a definite expiration date. Option C. Expiration dates are allowed only in commercial leases. Option D. The county recorder assigns the expiration date after closing. The correct answer is option B. Minnesota listing agreements must include a definite expiration date. Minnesota listing agreements must be written and include a definite expiration date. Automatic indefinite listings create consumer protection concerns and do not meet the required content rules. County recorders do not supply listing agreement expiration dates. Question 79. In St. Cloud, a new applicant asks which combination best describes the salesperson licensing path in Minnesota. Option A. Be at least 21, complete only Course I, and work independently after passing the exam. Option B. Complete continuing education before any pre-license education and apply directly without a broker. Option C. Be at least 18, complete courses 1, 2, and 3, pass the exam, associate with a broker, and receive Commerce Department approval. Option D. Pass only the national exam and begin practicing while the application is pending. The correct answer is option C. Be at least 18, complete courses 1, 2, and 3, pass the exam, associate with a broker, and receive Commerce Department approval. Minnesota salesperson licensing requires age eligibility, 3 30-hour pre-license courses, examination success, broker association, and approval by the Commerce Department. The other choices either remove required courses, allow independent practice, or treat a pending application as authority to act. Those alternatives do not satisfy the licensing sequence. Question 80. A property has monthly gross rent of $1,500 and sells for $165,000. What is the gross rent multiplier? Option A, 6%. Option B, 7%. Option C, 90%. Option D, 110.0. The correct answer is option D, 110.0. Gross rent multiplier is price divided by gross rent for the same period. Cap rate, commission rate, and loan-to-value percentage measure different relationships. GRM is a quick income property comparison tool, not a complete valuation method. Question 81. A facilitator working with Riley in Duluth performs services without representing either side. Which fiduciary duty generally remains unless expanded by written agreement? Option A, confidentiality. Option B, loyalty to the seller only. Option C, obedience to the buyer's investment goals. Option D, advocacy for the party paying the commission. The correct answer is option A, confidentiality. A facilitator does not act in a fiduciary capacity as a buyer's broker, seller's broker, or dual agent, but confidentiality remains a duty unless the relationship is expanded by written agreement. Loyalty, obedience, and advocacy belong to agency representation, not ordinary facilitator status. Commission payment does not create fiduciary representation by itself. Question 82. A factory closure outside the neighborhood reduces demand for nearby homes. What type of depreciation does this suggest for Reese in Bemidji involving a vacant lot priced at $256,000? Option A, physical deterioration only. Option B, external obsolescence. Option C, functional obsolescence only. Option D, accession. The correct answer is option B, external obsolescence. External obsolescence is value loss caused by factors outside the property, such as economic changes or adverse surroundings. Physical deterioration is wear and tear, while functional obsolescence is internal design deficiency. A factory closure is external to the property. Question 83. Which ownership estate gives Finley Okafor the greatest bundle of rights with no stated end date or condition? Option A, estate at sufferance. Option B, life estate. Option C, fee simple absolute. Option D, license. The correct answer is option C, fee simple absolute. Fee simple absolute is the broadest ownership estate and can continue indefinitely. A life estate ends with a measuring life, an estate at sufferance arises from holdover possession, and a license is permission rather than an estate. The key phrase is ownership without a stated end date or condition. Question 84. A parcel borders a lake near Moorhead. Rights associated with use of the lake shore are commonly called what? Option A, riparian rights only. Option B, fixture rights. Option C, novation rights. Option D, littoral rights. The correct answer is option D, littoral rights. Littoral rights generally relate to property bordering lakes, seas, or oceans. Riparian rights involve rivers and streams. Fixtures concern attached property, and novation is contract substitution. The lakefront fact drives the answer. Question 85. A lot has 110 front feet worth $120 per front foot. What is the indicated front foot value? Option A, $13,200. Option B, $536. Option C, $18,980. Option D, $818,750. The correct answer is option A, $13,200. Front foot valuation multiplies frontage by the price per front foot. Tax proration, commission, and income capitalization rely on other formulas. The question asks only for the land value indicated by frontage. Question 86. In a lien theory mortgage state such as Minnesota, what does the mortgage usually give the lender for Avery in Egan involving a townhome priced at $190,500? Option A, immediate ownership and possession of the property. Option B, a lien securing repayment while the borrower retains title. Option C, a life estate measured by the borrower's life. Option D, a leasehold estate for the loan term. The correct answer is option B, a lien securing repayment while the borrower retains title. In lien theory, the mortgage gives the lender a security lien rather than immediate title and possession. The borrower retains legal title unless foreclosure changes ownership. Life estates and leaseholds are different interests, not the ordinary mortgage relationship. Question 87. Under Minnesota licensing rules, what happens when a salesperson's association with an actively licensed broker ends for Taylor in Rochester involving a small retail building priced at $286,500? Option A, the salesperson may continue independently for 90 days. Option B, the salesperson automatically becomes a limited broker. Option C, the salesperson's license becomes inactive until proper association is restored. Option D, the salesperson may transfer clients without broker supervision. The correct answer is option C. The salesperson's license becomes inactive until proper association is restored. A salesperson license depends on active association with a licensed broker. Ending that association makes the license inactive, so independent practice is not allowed. Automatic broker status and unsupervised client transfers are not part of the salesperson licensing structure. Question 88. A city takes private land for a public road after paying just compensation. What power is being exercised for Drew in Eden Prairie involving a farm parcel priced at $455,000? Option A is cheat. Option B, adverse possession. Option C, police power only. Option D, eminent domain. The correct answer is option D, eminent domain. Eminent domain is the government's power to take private property for public use with just compensation. Escheat transfers property to the state when no heirs exist, and adverse possession is private acquisition through possession. Police power regulates use but does not by itself describe a compensated taking. Question 89. A broker refuses to show listings unless a buyer also uses the broker's mortgage affiliate. What antitrust concept could be implicated for Riley in Bloomington involving a vacant lot priced at $268,500? Option A, tie-in arrangement. Option B, accretion. Option C, estoppel. Option D, substitution principle. The correct answer is option A, tie-in arrangement. A tie-in arrangement conditions one service on the purchase of another service and can raise antitrust concerns. Accretion, estoppel, and substitution are property or valuation concepts. Consumers should not be unlawfully forced into affiliated services. Question 90. An easement benefits a neighboring parcel by allowing driveway access across Drew Anderson's land. What type of easement is most likely? Option A, personal license only. Option B, easement appurtenant. Option C, trade fixture. Option D, a mechanic's lien. The correct answer is option B, easement appurtenant. An easement appurtenant benefits another parcel and usually runs with the land. A personal license is revocable permission, a trade fixture is tenant property, and a mechanic's lien secures payment for improvements. The presence of a benefited parcel points to an appurtenant easement. Question 91. An advertisement says a newly built townhouse is available only for adults with no children. What is the main fair housing concern? Option A. The ad forgot to mention the roof age. Option B. The ad uses a list price instead of an appraised value. Option C. The statement indicates a preference or limitation based on familial status. Option D. The ad includes the city name. The correct answer is option C. The statement indicates a preference or limitation based on familial status. Advertising cannot indicate a discriminatory preference or limitation based on familial status except where a valid housing for older persons exemption applies. Roof age, list price, and city name are not the fair housing issue in the wording. The problem is discouraging families with children. Question 92. A restaurant tenant installs removable ovens for the tenant's business. What are those items often called for Blair and Red Wing involving a mixed-use property priced at $229,500? Option A. Riparian rights. Option B. Deed restrictions. Option C. Remainders. Option D. Trade fixtures. The correct answer is option D. Trade fixtures. Trade fixtures are business-related items installed by a tenant and usually removable if removed timely and damage is repaired. Riparian rights concern water, deed restrictions limit property use, and remainders are future interests. The tenant's business equipment points to trade fixtures. Question 93. At the end of a Minnesota tenancy, what must a landlord generally do with the tenant's security deposit after receiving a forwarding address for Rowan and Stillwater involving a vacant lot priced at $368,000? Option A. Return the deposit plus interest or provide a written explanation of lawful deductions within the required time. Option B. Keep the entire deposit automatically as a cleaning fee. Option C. Apply the deposit to the broker's commission. Option D. Record the deposit with the county as a deed restriction. The correct answer is option A. Return the deposit plus interest or provide a written explanation of lawful deductions within the required time. Minnesota law requires the landlord to return the deposit with interest or provide a written explanation for lawful deductions within the required period. Automatic forfeiture, commission payment, and county deed restrictions do not match the security deposit rules. Security deposits remain tenant funds unless a lawful deduction applies. Question 94. A deed is signed by the grantor but never delivered to Kendall Nolan. Why is delivery important? Option A. Delivery sets the mortgage interest rate. Option B. Delivery shows the grantor's intent that the deed take effect. Option C. Delivery replaces legal description requirements. Option D. Delivery creates a leasehold only. The correct answer is option B. Delivery shows the grantor's intent that the deed take effect. A deed must be delivered and accepted to operate as a conveyance. Delivery reflects the grantor's intent that the instrument take effect. It does not set loan terms, replace the legal description, or create only a leasehold. Question 95. A buyer credit on a closing statement for assumed unpaid taxes generally does what for Morgan in St. Cloud involving a rental house priced at $407,500? Option A. Increases the seller's loan payoff. Option B. Eliminates title insurance. Option C. Reduces the buyer's cash needed because the buyer will later pay the tax bill. Option D. Creates a new listing agreement. The correct answer is option C. Reduces the buyer's cash needed because the buyer will later pay the tax bill. A buyer credit reduces cash due from the buyer when the buyer assumes a future obligation connected to the seller's ownership period. Loan payoff, title insurance, and listing agreements are separate closing or contract issues. Credits and debits must be read from the party's perspective. Question 96. Regarding commission language in a Minnesota listing agreement, which statement best reflects the required consumer notice for Avery in Eagan involving a small retail building priced at $343,500? Option A. The state sets one mandatory commission rate for all residential listings. Option B. The MLS sets the minimum commission for every listing. Option C. The buyer must always pay the listing broker directly. Option D. Compensation is determined between each individual broker and the broker's client. The correct answer is option D. Compensation is determined between each individual broker and the broker's client. Minnesota listing agreements must include a notice that compensation is determined between the broker and the broker's client. The state and MLS do not set a universal commission rate for every transaction. Payment arrangements depend on the agreement and cannot be assumed from the listing alone. Question 97. A city special assessment for a new sidewalk appears on a property record. What kind of charge is it most like for Emerson in Edina involving a lake cabin priced at $192,500? Option A. A charge against benefited property for a public improvement. Option B. A private broker commission split. Option C. A personal credit card debt. Option D. A title insurance premium refund. The correct answer is option A. A charge against benefited property for a public improvement. A special assessment is commonly charged against properties that benefit from a public improvement. It is not a broker split, personal consumer debt, or title insurance refund. Assessments can affect closing and ownership costs. Question 98. During a Minneapolis license renewal review, which continuing education schedule best matches Minnesota salesperson requirements? Option A, 10 hours every 4 years with no annual deadline. Option B, 30 hours before the June 30th renewal deadline, with at least 15 hours completed before the previous June 30th. Option C, 30 hours only during the first licensing year. Option D, only the required module with no other continuing education. The correct answer is option B, 30 hours before the June 30th renewal deadline, with at least 15 hours completed before the previous June 30th. Minnesota salespersons generally need 30 hours of continuing education before the June 30th renewal deadline, with at least 15 hours due before the previous June 30th. The other options understate the hours, remove the annual structure, or treat the module as the only requirement. Continuing education must be completed in the proper license period. Question 99. A landlord in Blaine deducts from a security deposit for unpaid rent and damage beyond ordinary wear and tear. What makes those deductions more defensible for Harper and Blaine involving a newly built townhouse priced at $222,000? Option A. They are based only on the landlord's dislike of the tenant. Option B. They include normal fading of paint from ordinary use. Option C. They are tied to permitted reasons and supported by a written explanation. Option D. They are taken without notice because deposits are always non-refundable. The correct answer is option C. They are tied to permitted reasons and supported by a written explanation. Minnesota security deposit deductions are generally tied to unpaid obligations or damage beyond ordinary wear and tear, with a written explanation when money is withheld. Personal dislike, normal wear, and treating every deposit as non-refundable are not defensible bases. Documentation is essential in landlord-tenant accounting. Question 100. Why is the Minnesota agency disclosure form given to Quinn Wilson not enough by itself to create representation? Option A. It automatically creates dual agency for every transaction. Option B. It replaces all purchase agreement requirements. Option C. It gives the consumer a license to sell property. Option D. It is a disclosure only, and representation requires a written listing contract or buyer representation contract. The correct answer is option D. It is a disclosure only, and representation requires a written listing contract or buyer representation contract. The agency disclosure form informs consumers about relationship options but does not create representation. Representation requires a written contract such as a listing agreement or buyer representation contract. The other choices confuse disclosure with dual agency, purchase contracts, or licensing authority.